State of Illinois, County of DuPage. In the Circuit Court of the 18th Judicial Circuit. People of the State of Illinois. Versus. Case number 2016 CM 1620. Muhammad Noah. Defendant. Verified defendant's motion to vacate the order, judgment of March 14, 2017 pursuant to 735 ILCS 52-14010DFORTHENTRYSMISSINGTTISMISSUANTTOSUANTTO725. ILCS 5-114-1 of 6 and 725 ILCS 5-114-1 of 8. 1. Now comes the consumer, Muhammad Noah, who is alleged to be defendant hereinafter. Noah, or consumer, pro se, and moves this honorable court to vacate the order of March 14, 2017, on voidness and constitutional grounds. 2. Furthermore, Noah is moving the honorable court for an order dismissing the charge of May 11, 2016, which must not have been filed, for frauds by the state's witness, S., a member of the management of Digital Doc Company, hereinafter, management of Digital Doc, and the lack of jurisdictions. 3. Noah is before the honorable court not to make the record voluminous or to embark on a very costly endless litigations in the resources of the people of the state of Illinois. 2. 4. Furthermore, and in bringing the charge by the management of Digital Doc against Noah and filing it, is generally in full disregard towards safety and the security of the public. 5. That the management of Digital Doc must not uses the resources of the judiciary of the people of Illinois as an advocate in protecting the deceptive business practices of the management of Digital Doc or any other company in promoting it. 6. The management of Digital Doc should have used its recourses in a civil court for its civil matters against consumer Noah, if any, instead of its charge, which reeks the stench of frauds and perjuries. 7. By its fraudulent charge, the management of Digital Doc did manipulate and did hurt Noah, his family and others. 8. The judiciary of the people of Illinois and its resources must concentrate on investigating and prosecuting the actual criminals to show its responsibilities towards maintain and or restoring the safety and the security of the people with and without the state of Illinois, as mandated by the constitutions. 9. Therefore, and to make it crystal clear herein, Noah strongly objects to any efforts to make the file of this charge voluminous or to coerce him to embark on an endless litigations in this charge, which must not have been filed to start with. 10. The management of Digital Doc presented the charge of May 11, 2016, alleging theft based on its deceptions before the honorable court because the management of Digital Doc did not make any mention of its signing the loaner phone agreement, Exhibit A, initiated in suggested by the management of Digital Doc, hereinafter, agreement, of March 30, 2016. With the consumer Noah therein. 11. The management of Digital Doc omitted its March 30, 2016, agreement, which divest Noah with the legally authorized possession, control, and the use of the iPhone 6. 12. However, the management of Digital Doc fraudulently alleging to be a victim in the above captioned cause, when it filed its charge by omitting the agreement. Noah included in attached the agreement, Exhibit A to his filed March 14, 2017, motion to dismiss for prejudice. 13. The perjurious and fraudulent charge of the management of Digital Doc against Noah clearly demonstrates, and beyond any reasonable doubt, that the management of Digital Doc is totally disregarding and violating Noah's human rights, legal rights, and his constitutional rights too. 14. Therefore, the agreement, Exhibit A, herein in Noah's March 14, 2017 motion to dismiss, is the Fundamental evidence, which flies in the face of the management of digital doc and debunks the frauds and the perjuries of the charge against the consumer NOAA. Therefore, the agreement, Exhibit A, proves the charge of the management of digital doc to be wreaking deceptions, frauds, and perjuries. 15. However, the management of digital doc did not include the agreement, Exhibit A, or even mentioned it in the record of the charge against the consumer NOAA in the charge of the management of digital doc in above captioned cause. 16. Consequently, the management of digital doc did not include the fundamental fact of the agreement, Exhibit A, which vests NOAA with the legally authorized possession, use, and control of the loaner iPhone 6 in the charge of the management of digital doc before the Honorable Court, but the management of digital doc omitted and excluded the agreement therein. 17. Therefore, the charge against the consumer NOAA by the management of digital doc in the above captioned is very clearly grounded in deceptions, exclusion of fundamental evidence, frauds, and perjuries upon the Honorable Court by the management of digital doc. 18. That the charge against consumer NOAA of the management of digital doc can never be warranted by the established laws because it is derived from, and based upon the exclusion of, the agreement, which is one of the fundamental evidence herein. 19. The charge of management of digital doc is the frauds and the perjuries of the management of digital doc, such as but on the Honorable Court in the unconstitutional complaint against NOAA. 21. NOAA is moving to vacate the order of March 14, 2017 pursuant to 735 ILCS 5-1401 on voidness grounds because the said order was obtained by fraud and perjuries upon the Honorable Court pursuant to 735 ILCS 5-1401, which states that relief from final orders and judgments, after 30 days from the entry thereof, may be had upon petition as provided in this section. Writs of error coram nobis and coram vobis bills of review and bills in the nature of bills of review are abolished. All relief heretofore obtainable and the grounds for such relief heretofore available, whether by any of the foregoing remedies or otherwise, shall be available in every case by proceedings hereunder, regardless of the nature of the order or judgment from which relief is sought or of the proceedings in which it was entered, except as provided in Section 6 of the Illinois Parentage Act of 1984, there shall be no distinction between actions and other proceedings, statutory or otherwise, as to availability of relief, grounds for relief or the relief obtainable. F. Nothing contained in this section affects any existing right to relief from a void order or judgment, or to employ any existing method to procure that relief. Source: PA 99-85, F 1-1-16. 99 to 384, F 1-1-16, 99 to 642, F 7-28-16, 100-1048, F 8-23-18. 22. The 2-year limit is inapplicable to motions to vacate a void judgment, which may be brought under Section 2-1401 at any time. See the Supreme Court of Illinois in Sarkeesian v. Chi. B.D. of Eject 201 Ill 2D 95, 104, 2002. In a motion to vacate a void judgment, the allegation that judgment or order is void substitutes for and negates the need to allege a meritorious defense and due diligence. 23. The rule that a void judgment, order, or decree may be attacked at any time or in any court, either directly or collaterally, without any showing of diligence or a meritorious defense. Evans v. Corporate Services 207 IL, App 3D 297, 301, 152 IL, DEC 191, 565 NE 2D 724, 1990. 24. 735 ILCS 5 halves minus 1401 F. Nothing contained in this section affects any existing right to relief from a void order or judgment, or to employ any existing method to procure that relief. Not even res judicata bars NOAA from moving the court to vacate the void order of March 14, 2017. 25. Not even res judicata is applicable when attacking a judgment on voidness grounds. See the Court in Miller v. Balfour, 707 NA 2D 759, at 764, 303 IL. App 3D 209, which states that he doctrine of res judicata is not applicable where a judgment is void. Otwell v. Otwell, 167 IL. App 3D 901, 909, 118 IL, DEC 873, 522 NE 2D 328, 1988, and void. Judgments are always subject to collateral attack for lack of jurisdiction or fraud of the state's witness, S, upon the court in the complaint against NOAA in re marriage of Verdung, 162 IL, App 3D 374, 389-90, 113 IL, DEC 645, 515 NE 2D 454, 1987. Jurisdiction involves not only the power to hear and determine a given case but also the power to grant the particular relief requested, and every act of the court beyond its jurisdiction is void. People ex rel. Bricka v. Village of Lake Barrington, 268 IL, App 3D 420, 423, 205 IL, DEC 850, 644 NE 2D 66, 1994. Emphasis added. 26. Furthermore, Illinois Supreme Court stated in Wanzer v. Bright, 52 IL, 35, 40-41, 1869, that it is a firmly established rule of practice that courts will never permit the filing of fraudulent charge of the management of digital doc, use of their process. And when it is attempted by the management of digital doc, the court will promptly interfere. Pursuant to No's motion, the court to prevent its process from being made the instrument for effectuating the fraud of the management of digital doc by setting it the complaint for fraud upon the court aside. It can never be tolerated that such *41 fraudulent perjury complaint against NOAA process shall be debased to the purpose of fraud and oppression in the attempt of destroying No's life by having theft charge on his record. The pure fountains of justice can never be so polluted with the oppression by frauds and perjuries of the management of digital doc. The courts were created for the administration of justice for NOAA but not to illegally oppresses NOAA by the fraudulent charge by the management of digital doc, and they in their process can never be used for the purpose of oppression on NOAA and to perpetrate fraud of the charge of the management of digital doc upon the court and defraud NOAA and wrong on NOAA or their process of filing perjury fraudulent complaint fraudulently obtained and employed in the fraudulent complaint against NOAA to enforce a fraudulently alleged right, however just and in spite of being not legal. Emphasis added. 27. Also Illinois Supreme Court in Wanzer v. Bright, 52 IL, 35, 41-42, 1869, stated that it has been repeatedly held in this country that no court will take jurisdiction of a party, such as NOAA, where it is obtained by fraud and perjurious complaint against NOAA. *42 Williams v. Bacon, 10 Wend. 636, Snelling v. Watrous, 2 page 314, Carpenter v. Spooner, 2 Sandif. N. Y. 717 Lever v. Robinson, 3 Dewar 622. No rule of law is more uniformly recognized and enforced than that a valid and lawful act cannot be accomplished by unlawful means of the fraudulent complaint against Noah, and in such cases, as in the fraudulent complaint against Noah, courts will restore the injured party by dismissing the fraudulent complaint against Noah to his nose rights of being free from oppression. Emphasis added. 28. The court in Evans v. Corporate Services, 565 NE 2D 724, 727 to 28, 207 IL, App 3D 297, 30102, 152 IL, Dec. 190, 2 Dist. 1990, stated. W.E. point out that a void judgment, order or decree, of March 14, 2017 Exhibit B, may be attacked at any time or in any court, either directly or collaterally. R.W. Sawant & Co. v. Allied Programs Corp. 1986, 111 IL, 2D 304, 309, 95 IL, Dec. 496, 489 NE 2D 1360. Without any showing of diligence or a meritorious defense, Sawant, 111 IL, 2D at 309, 95 IL, Dec. 496, 489 NE 2D 1360, Francisco v. Francisco, 1980, 83 IL, App 3D 594, 596, 39 IL, Dec. 153, 404 NE 2D 537. A court has inherent authority to expunge, vacate the order of Exhibit B, void acts, of the fraudulent complaint against Noah and the order of March 14, 2017, from its records, the above captioned cause. Dahl v. Grenier, 1984. 126 IL, App 3D 891, 893 to 94, 81 IL, Dec. 870, 467 NE 2D 992, IL, Reverend Stat, 1987, CH. 110. Par. 2-1401. A judgment or order, of March 14, 2017, Exhibit B, is void where it is entered by a court which lacks jurisdiction over the parties, Noah, or the subject matter, the fraudulent complaint of the management of Digital Doc, or lacks inherent power to enter the particular order or judgment. Patens Corp. v. Petrozzini, 1988, 170. IL, App 3D 617, 618, 121 IL, Dec. 367, 525 NE 2D 173, or where the order is procured by the fraud of the management of Digital Doc Vulcan Materials Co. v. B. Construction Co. 1981, 101 IL, App 3D 30, 40, 56 IL, Dec. 465, 427 NE 2D 797. Quote. Emphasis added. 29. The court in Defilips v. Defilips, 211 NE 2D 147, 150, 63 IL, App 2D 19, 24, 1965, stated that it is elemental law that a void judgment, of March 14, 2017 Exhibit B, may be set aside at any time. 23 ILP. Judgment Section 166. It is held in Barnard v. Michael, 392 IL. 130, 63. NE 2D 858 that a judgment entered by a court which lacks jurisdiction of the parties Noah because of the fraudulent charge of the management of Digital Doc, or the subject matter, or which lacks the inherent power to make or enter the particular order involved is void and may be attacked at any time or in any court, either directly or collaterally. See Woodward v. Rule 355 Ill. 163, 188 NE. 911. Emphasis added. 30. Furthermore, and in support his motion Noah includes and incorporates herein his motion of March 14, 2017, which he filed in court, as if the entire motion of March 14, 2017, and its attachments are restated and included herein. Conclusion. The charge of the management of Digital Doc is based on perjuries, frauds, deception. Consequently, the management of Digital Doc obtained the order, judgment of March 14, 2017. Exhibit B through and by its fraud upon the court therefore, the March 14, 2017 order, judgment is void and should be vacated and the unconstitutional charge against Noah must not have been filed and should be dismissed as unconstitutional charge. Wherefore, the consumer Muhammad Noah prays the court for the order that A. Vacate the order, judgment of March 14, 2017 Exhibit B. B. Dismiss the charge of May 11, 2016. C. Refund the $110 the cost of the illegal charge against Noah, and D. For any other relief the court deems fair and just for Noah. Respectfully submitted. Blank. Muhammad Noah, pro se. Verification by certification. Under penalty of perjury as provided by law pursuant to 735 ILCS 1-109 of the Code of Civil Procedure. The undersigned certified that the statements set forth in this instrument are true and correct, except to matters therein stated to be on information and belief, and as to such matters the undersigned certifies that he verily believes the same to be true. Blank. Muhammad Noah, pro se.